I read them while I was waiting, so I can make a motion to approve the minutes. Aye.
I think it's, oh no, now it's on. So I don't know, does everybody know about the inquiry we had, or it's like, there was a lot of email conversation about it. You don't know the subject, okay. So, we received an inquiry directly from a resident. And she actually asked Kelly directly for the form since the form wasn't yet loaded on the site. And so Kelly sent that to her. It was pretty clear immediately that we were not sure if we would have jurisdiction. And so we just sort of let her know we needed to check with our counsel, which took a little while, and we just kind of kept her in the loop of what we were doing in the meanwhile. And I'll fill you in on what the subject was, because I think it would have been a very interesting case for us to discuss. And we could kind of discuss it blindly, but just for point of interest. But our attorney said we did not have jurisdiction. So we let her know that, and that was sort of, it was a very interesting case. Resident of Yardley of Lower Makefield, who works remotely for a company outside of the state. I think it was Massachusetts, if I remember correctly. And she was pregnant, and she had been termed by her employer, and I don't have her inquiry in front of me as well. I don't remember the details exactly, but I know Stan and Cathy both saw it. So feel free to add more. And she was concerned about the way in which she had been let go, and was hoping to get more severance time, and felt that there was some record of doing this with other pregnant employees. So I just want to add anything.
Yeah, I saw an email, but not,
Oh, you didn't see the whole-
nothing from the inquirer.
I could probably pull up the inquiry if we want to discuss it.
I have,
I'm sorry.
no, I have a copy at my desk if you did want to look at it. I also wasn't sure, like, I guess this is something that we haven't discussed yet together of like, does it go by email to everybody? Like, I don't know if there's something in the ordinance that says that shouldn't, or I think the process on here says it should just go to the chair first. So I was hesitant to send it out to everybody, and
it was great to have a dry run. I was also about to go on vacation out of the country, and I felt like, oh my God, we have to get back to her before I go. And what was our time frame? So I felt really glad to know that. I mean, I was sorry that we couldn't. Hey, Melody. I was sorry that we couldn't weigh in and try to help her.
Can I inquire as to why it was determined that we do not have jurisdiction? What was the basis for that?
I also have that email as well. I have a big full report from our solicitor on why they came to their conclusion. But Tara, if you want to shed light.
So originally, the attorney said that she thought that we would, our attorney said, we thought we would ask her to formally file a complaint, and then we would proceed by there, but they wanted another day to think about it. And then after several days, they came back and said, on further discussion and research of this matter, we've come to the conclusion that Lower Makefield Township Human Relations Commission does not have jurisdiction in this matter. And then the analysis.
Right, that's what I want.
Very long, Stan.
Yeah. I know the basis of it if you want. So essentially, the resident was also inquiring with a Massachusetts-based Human Relations Commission as well as the Pennsylvania Human Relations Commission. She has a Massachusetts-based lawyer as well involved in the situation. The she inquired with the PAHRC, but they told her that because she is the only employee in the state, they don't have any grounds. And from the analysis that our solicitor gave us, we do not have the jurisdiction as per our ordinance to go over the head of the PAHRC. So
That really makes sense.
That is, that,
do
that's worse than doesn't make sense. That-
carry out, I guess,
So-
talking.
Here's what concerns me. So under the state statute, the Pennsylvania Human Relations Act, the PHRC has jurisdiction in matters involving companies that employ more than 4 people. Our jurisdiction is conferred at 1 employee. So that, based on what little we know now, this would be a situation where the Pennsylvania Human Relations Commission would not have jurisdiction, so you would think we would. The other thing that concerns me is it would be interesting to know whether the Massachusetts state agency that you referred to has determined that they have jurisdiction. It's possible that this individual would be left without a place to file. So I think we should take a look at and analyze this a little more closely.
Do you have the description in front of you, Tara? She gives more context to exactly, the wording is very.
Yeah.
Yeah, I can grab
So
it.
what I had received a summary email in which what was described was that the individual inquiring was advised by her counsel to file with the state agency and then with us sort of as a backup. To which my question, and this is not a question of jurisdiction, it's a question of discretion. The question I had was, well, if you are proceeding in the PHRC and they're investigating, then maybe we should just back up. But that seems to not be jurisdictional, just maybe a question of what we want to do. I'm concerned that this person may have been deprived of a remedy when our ordinance provides a remedy.
So I can read you the entire response.
Well-
That's fine. I'm happy to. I also have to say that because you're an attorney, you have a different perspective on it that I'm not sure, like, there's a little bit of an expert in the jury box thing going on,
Right.
right? Because we can't question our counsel's counsel, right? As a commission, we can push back and ask her to reconsider, but I wouldn't feel comfortable going to her and being like, well, the attorney on our counsel. Right, so I mean.
Well, I would, and I'm not saying she's wrong. I haven't seen her analysis, but
Let's
yeah.
can decide. I mean, I'm not opposed to taking any particular action if we feel like we want to go back and say we would respectfully ask you to reconsider. And I think somewhere in our draft might be what happens if this happens again. But okay, so the first thing she says is Lower Makefield Township Human Relations Commission is a body created and governed by Chapter 12, blah, 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 just who we are. And then she says, among other things, the code prohibits discrimination in employment. 12-3, definition of discrimination. The employer is defined as the person who employs one or more employees within the town. Here, I won't read her name because it's not relevant at the moment. The person has filed a complaint against her employer, a Boston-based health services company, for a discriminatory act on the basis of sex, gender, I should say. The employer employed only one employee in Pennsylvania, the resident of Lower Makefield Township. The complainant fulfills the jurisdictional requirements under Chapter 12 of the LMT Code. It does not fulfill the requirements under the Pennsylvania Human Relations Act, which really doesn't.
That
I agree with you.
yeah, that's why we should consider intervening.
Then the PHRA similarly prohibits discrimination in employment on the basis of sex. However, employer is defined in the act as an entity that employs at least 4 employees. So she's now referring to the Pennsylvania.
Right.
Code. The question is therefore whether the Lower Makefield Township Human Relations Commission may impose requirements or undertake procedures that the Pennsylvania Human Relations Commission would not be permitted to impose. And she says the short answer is no. which I have to agree with Stan, by definition, our
Well,
our LMT code
Is-
specifically says something
and
different.
also includes specific classes. This one, the specific classes that are not included under the Pennsylvania Human Relations Act. So if there's authority, like a case that says that conclusion, like to see it.
She goes on and she says the PHRA enables the creation of local human relations commissions and states that they may be granted full powers and duties similar to those exercised by the Pennsylvania Human Rights Commission under the provisions of this act at 962.1. At first blush, that language would seem to suggest a modicum of wiggle room between the powers and duties of local human relations commissions and the PHRC, because the General Assembly has required the powers and duties between the two to be, quote, similar as opposed to, quote, the same. However, the Commonwealth Court has likely foreclosed this interpretation, at least in regards to this person complaining. In the city of Pittsburgh,
Commonwealth.
Oh, a case.
Yeah, the city of Pittsburgh. Yes.
the court explains that the authority of local human relations commissions is derived from the PHRA 782 A.2D, or whatever. Further, the court explains that the limits of the PHRC's powers are to be strictly construed as the powers of the PHRC, the powers of the local governing body to create and empower local is circumspect. The court states that, quote, it is clear that the General Assembly, while desirous of extending to municipalities the right to establish local commissions, did not intend to extend to local commissions powers and duties above and beyond those possessed by the PHRC. In which case I would say, why is our code drafted that way? Why doesn't our code just say CPHRC?
Well,
Why didn't it write a whole
we-
code?
So we do have a separation of powers, and it is possible that exercising its rights, the Commonwealth Court has determined that the legislature has essentially outkicked its coverage by allowing ordinances to extend past. But I'd like to read that case. So, but now at least I understand what council's relying on. Her analysis is right, the same as ours, but she says this case constrains us. So we should look at it, or I'd like to look, but not now. Well, I would analyze it.
Specifically about what it included, and then we can.
Yeah.
There was a lot of like gray
The entire thing.
the inquiry.
Like everything we would have needed to process it, but we considered it an inquiry.
And I think one of the reasons why I advised her to fill out the inquiry first and foremost and not the complaint is because she had relayed to me that she already filed with the PHRC, but under the direction of her lawyer said, you probably aren't going to get any remedy from the PHRC because you're the only employee in the state. So
I mean, the funny thing is, right, that if she had applied to us first,
maybe.
we would not the state, we wouldn't have had the states turning her down. So we would have just asked our attorney if we had authority.
I also did reach out to the PHRC about it and they confirmed that it wouldn't be a case that they'd be able to hear. So I have that written down too. I have that.
But on the basis of there only being one employee, but that's easy. If they didn't have jurisdiction, that's easy. The question is whether we're constrained beyond what's in our ordinance. So I'll look at this case. Sounds
Yeah.
like our solicitor did a lot of research.
I think it's
Yeah.
good for everyone to hear about it. I appreciate that. Dan brings an expertise there, but I'm also feeling like if we're going to talk about further, unfortunately,
Well, I think Kelly can send it to all of us via email and then we can always read about it. I mean, it might be worth having the solicitor come to a meeting and talk to us because if this is the case, then like you said, why was the ordinance written that way? I mean, I'm trying to remember whether she wrote it or the solicitor before her wrote it.
Ours is written identical to every other. It's identical to every other. So the Commonwealth Court, it wouldn't be surprising if the Commonwealth Court has ruled on these issues. So that's not surprising. And whether we like and agree with the Commonwealth Court's decision or not, that's the law.
Right.
Um,
I guess my question would be for her is what Tara just said, is that if we didn't know, like if she didn't tell us that she had been denied by PA or HRC, how would we have handled it? We would have still sent it to the solicitor, and then what would she would have said?
we don't know. We don't know.
So I can forward everything that I sent to you, including the analysis and the residence inquiry form. You're fine that I disperse? Okay, I'll forward it.
I think we maybe should put it on the agenda for next meeting. Yeah.
Yeah, the inquiry was based on sex and familial status and sexual orientation.
But it sounded like there was a pregnancy element to it. So,
Yeah.
so there's a federal law as well that she wouldn't qualify for. Well, shouldn't say that. She might qualify for protection under the federal law, but might not because she's one in Pennsylvania. I'd have to look at that. But was the company larger in Massachusetts, or we just don't know?
27 employees.
Yeah. Yeah. So the FMLA would not apply, which is probably the rubric under which her claim really would fall, best. But, okay.
So I would move that we send the information to all of us and we bring it up for discussion at the next meeting. Okay, then let's just do it.
It wasn't formal, it's not formal. Do you need a formal motion?
I
Would
don't,
anyone like to second?
Sure.
Okay, I'm looking for seconds and would everyone agree that we discussed it at the next?
I'm gonna go into my work computer and send this from my work computer because I don't want to download this form on my personal computer. Can somebody take the minutes? Oh, no, you don't want me to send it over now?
So just
Okay.
send it later. I mean,
Send it
doesn't-
after the meeting's over then in that case. Okay.
They just decided they wanted to be able
Alright.
to read it when they had time and discuss it next time.
Well, it gives us,
the issues of where it is wasn't the issue. In other words, the fact that it was in that.
Well, that's
Situ-
why we
okay.
asked
So-
the attorney,
Well-
had the employer been local, we wouldn't have asked.
Yeah, probably,
So-
yeah, would have been more clear cut, I
Re-
think.
Remote employees are deemed to be employed where they're working. So the fact that it's a Massachusetts company doesn't prevent it from being subject to Pennsylvania law. Sounds like the issue here is whether we have jurisdiction over an employer with fewer than 4
Mhm.
employees in Lower Makefield Township. That sounds like, but we'll read it and see.
Yeah, it was confirmed that was confirmed by some sort. I think maybe the solicitor had confirmed that
Right.
if you live and work remotely, wherever you're conducting the business is where
Yeah.
so
The-
it would have been, if there were more than 4 in the state, it would have, even if, because it
Right.
was remote.
Based on what I've heard, the issue seems to be whether the Commonwealth Court's decision constrains our rights, and our solicitor seems to think so. That's a start.
Another interesting thing though, Beth has said, which is if there had been more than 4 people working remotely in the state, it then would have fallen under PHRC, but she still would be protected by ours
Mhm.
as the only person in our district, but
Right, and I think at that point, the question becomes, should we do anything if the Human Relations Commission isn't? And one thing I'd suggest in that circumstance we could do is just hold it and say, we're just gonna hold this. Because while you're pursuing things in the state agency, there's nothing we can do. But if something goes awry in the state agency, you might want to come back to us and we'll wait. So I think there's things we can do short of telling someone, no, we can't help you, and sending them away. But certainly not if we don't have jurisdiction, then we have to send them away.
The PHRC also did tell me to advise her that maybe there's something with the EEOC that she could file. They sent that to me.
That was the fun.
Sent that back to her,
Right.
back to her.
That was the federal law. I'm quite sure her Massachusetts lawyer knows that.
Yeah.
Okay, so we have the first agenda item for our next meeting. Thank you. We just review the input. And I think, maybe it would be worthwhile, Kelly, for us to see if one of you can join us for that. Since we know that.
Do you want me to set up a meeting, like, out of the public forum, or invite her to the next meeting? Yeah, I can reach out to her, sure.
Okay. That was item 3. All right, the next item on our agenda is to develop a response to inquiry workflow and the timelines. And by timelines, what I meant was, and how long do we have to do all these things? Because that was the thing that was getting me hypertensive as I was trying to leave. So Kathy, do you want to take a stab?
Yeah, I mean, and I did, honestly, I didn't get to this until like 3 days ago. And I showed it to Byron and he said the same thing about the timelines, but I thought that we could kind of flesh that out a little bit more here. So the contact most likely is going to come through the township. And then Kelly, I just wrote township liaison because, you know, it may not always be Kelly.
Yeah,
Um,
sorry to interrupt, but for context, the phone call actually came to Katie's phone.
Right.
And she was out that week that it came, and Jim Majewski picked up her phone calls,
Mhm.
picked up her messages, and he forwarded it to me.
Yeah, I mean, and if it came in on this, I'm assuming Katie would send it to
Yeah,
you. So-
exactly.
So by minor issue, I meant when we talked about somebody wants us to speak or to come in or anything like, you know, anything that's not, yeah, so we could call that an administrative issue. Does somebody have a pen I can use? Do everything on the computer, so I can make that administrative issue. And then I first added the legal consult needed because that's what just happened. So, you know, that's at the point that Kelly had sort of deemed that, you know, we needed more information. And it went to the attorney. I don't know that we could put a time frame on that.
Yeah, it's tough.
Because I know the attorney, you know.
Well, I think the first time frame is, what's our time frame from receiving it to action? How long it takes the attorney is out of our hands.
Yeah, I mean, I feel like if it's, okay, so that's administrative.
Statutorily?
It should
like,
be,
Statutorily, it's like, I was reading over today, like 30 days, like we have 30 days to reach out to the person.
Yeah, ordinance has some
It
time.
has timeline in subsection.
but administratively, that's like kind of us dealing with it and stuff. I mean, I think once it comes into you or whoever is dealing with it from the township, it should be like, you know, 48 hours. or
Within the
2
day,
days, 2
yeah.
business days.
Yes, yeah.
Let's just say 2, because, you know, whatever. Before that happens.
That's what I was.
Yeah. And then either way, it would go to the chair and HRC duty person. I do agree with you. And, you know, what you said, Kelly, about like, oh, you were reluctant to send it to all of us. I mean, I guess it's more of an action item because we talked last time about one of us being assigned on call each month. So that's what I meant, my duty person. I think a chair should get the copy of it no matter what, but I do think actually everybody should get a copy of it.
Yeah, I don't think it's explicitly stated in the ordinance. It's just stated that once it comes through us, the township manager has to send it to the chair, but in this case, liaison. So I fit in on the piece, but it sends it to the chair and it doesn't mention that it goes to any other committee members. So that's why I just reached out to you for it.
Well, I guess the question is there any reason it can't go out to the rest?
That's a good, yeah, that'd be interesting to know, to,
Yeah, I mean,
I can
maybe that's something
ask.
you could follow up on because otherwise then it's going to go to, let's just say Tara as the chair, and then she's going to forward it to all of us in the duty person, which seems like a needless extra step.
I feel like if I
Right.
Mhm.
And then the HRC duty person gives assistance as needed. So either walks them through the inquiry or helps them fill out a complaint or refers them to PA HRC or anything else, you know, so I didn't feel like I needed to put like everything that they could do. And then it sort of went into, so the reds were all the stop points, issue addressed without complaint or complaint filed. I mean, I guess we should put a little bit of a timeline on the HRC duty person communicating with them. I think that needs a little bit more time because we're not just dealing with our schedules, we're dealing with the other person's schedule. Maybe saying like 14 days or something. For whoever of us works with whoever of them. And I'm saying 14 days as an end, like it doesn't mean we wait 14 days, but if we're scheduling to meet and communicate with her, and I'm also open to another, I'm just sort of pulling that number out of my tush.
But like as an example, so let's say that this had gone, we got the attorney, on it that, yes, we have jurisdiction, and we would have said
Mhm.
that would have been the only feedback back to her until she decided to file, which could be now or never. Right, so.
Yeah, so I guess in between complaint filed and response paperwork, it has to be complaint receipt. Well, I guess it should be complaint received then instead of filed.
Right, 'cause it's not automatic.
Right.
I
And
think
that's where I put issue addressed without complaint. Like if they decide like, I don't need to make a complaint, or maybe I just want you to mediate this or whatever else. I mean, I don't know if we would mediate it without a complaint, but that's probably a whole nother hour discussion another day. And then response paperwork sent to both parties. Stan, I know you're talking about deadlines in there. Does that?
I just pulled it up.
Yeah, so I think that that's where we would need.
I also think there's another issue that would be an exception to what we're putting down as our
Mhm.
workflow. And that is if we triage a matter that has urgent, someone
Yes.
gets to us on day 170, we should probably not wait 11 days to tell them that they have to file within 181, within 180. So, and again, that's a triage. Someone opens it.
Well, yeah, I mean, I think we have to leave it to the triage person to kind of determine those things. And obviously, if, we're triaging it and we know that it's, day 170, we're all gonna, I think, move a little faster. Although I guess the other question that's gonna come up at some point is how do we do a hearing? Because God knows it's.
yeah,
Like,
we would have to designate two hearers to.
oh, it doesn't have to be the full commission?
Yeah, no. So when it does come to a hearing, if it were, it's two members are the hearing officers.
So I'd like to see the whole description of that.
Yeah,
I really was wondering.
I have it
Right.
up here. I mean, we can discuss
And
choosing those two individuals so that we have it set up for in the future.
That it would- the person who was on, the duty person,
Mhm.
chair, and if I wasn't available, the Cathy,
Mhm.
whoever else was available.
Mhm.
So I just,
Couldn't it be more than two people?
it says a minimum of 2.
A minimum of 2.
Say,
Yeah.
an arrangement, please, as many of you want to join
Yeah.
us, please. join.
So we would schedule around the 3 people, the complainant, the chair, and the duty person or the intake person, triage person, whatever the heck we're calling them. And then, but we would then invite everybody else. Because I think everybody would be interested in coming if they could.
mhm.
I think the one deadline that I see that is imposed by ordinance that fits on this
Mhm.
is we're supposed to serve the complaint within 30 days.
So once we receive it, the paperwork needs to go to them within 30 days. So
Needs to be served on the employer, right?
to there.
It doesn't seem like there's anything that's required by the ordinance
How
until
long-
after we receive a complaint.
Who,
After
after,
we post it.
after we serve them, how long do they have to respond?
60 days.
You said 60 days?
Yeah, the respondent
Yeah.
shall file a written verified
218, right.
answer within 6 days
Yeah.
of receipt.
6 days or
60.
0. Okay, so then after that, after response paperwork, it's like 60 days, then a hearing is scheduled.
Well,
And then,
That's where I had another comment on what I think we would want to add to our regular duty, which is complaint gets filed, answer gets filed. I think before we not schedule a hearing, but before we have a hearing,
Mhm.
we would want to at least consider whether we want to reach out to both sides to attempt to offer conciliation or mediation or encourage that they at least discuss a process of resolution before we, have the hearing.
Is that laid out in the ordinance?
It's a fact-finding conference, so 30 days after.
That's really the hearing, the fact
Yeah,
finding.
so are you
Okay, so
opposing?
HRC hearing is the fact-finding conference, because I want to make the language match as much.
Yeah, that is correct. That's,
No, 30 days to when we have to serve them with the papers, 60 days they have to respond. And then I don't know if there's another time frame saying how soon we have to have the fact-finding conference.
30
Yeah.
days after an answer has been received, I believe, from the
or,
response.
right, or
If
60
they don't
days.
answer, right?
60 days if they don't answer. It's 60 days after the complaint.
So then
Okay,
we
so-
can invite them to voluntarily participate.
So 30 days after we receive the response, or 60 days if we receive no response.
The request to voluntarily participate in the fact finding is not the same as asking if they want to have a mediation or conciliation. That's just because the fact finding is where the decision's made. So that's it. They don't have to come. We don't, yeah. Yeah. That's where we find facts, determine facts, right? Not,
The fact-finding is the hearing. It's just the ordinance language. Yes.
But Dan, with the offer of other kinds of alternatives like a conciliation, like you mentioned, would that occur before the fact finding or after?
well, before, if they're going to do it. See, there's not a lot of time here.
Mhm.
The majority of this is pre-complaint. We're all the way down here at the bottom where there's a complaint, and an answer and a fact finding. And ordinance says so, by the way. Doesn't give us a lot of time, but
So it sounds like at this part, Kathy, if we can make this part of the Visio small.
Yeah.
And then we can say, response to paperwork received, and then have more decision trees, like open to mediation, do this, otherwise you schedule.
well, it looks like we kind of have to schedule that fact finding. Yeah, you have to schedule it, but you don't have to have it if the parties can work it out beforehand. Or let me tell you what the PHRC actually does. They don't have this strict deadline like us. I mean, they have fact finding, but they're not required to do it so quickly. They generally ask the parties, hey, do you want to mediate? If so, we'll stay the matter, suspend it till after the mediation, and then if you don't settle it, we'll reinstate it. So I'm just suggesting that if we have a complaint and an answer, it would be nice for us to at least look at that. Some things aren't settlable, others are. And it would be nice of us to correspond with both sides in a neutral way to say, have you thought about resolving this? Would you like us to, devote some resources to that?
I have all kinds of questions about what does that actual correspondence with both parties look like? Because I started envisioning myself, am I calling people? Just am I sending emails? How do I even know how to reach? We have a phone number, but if they don't call, you're leaving your personal number. There's a lot of stuff that we need to actually operationalize what it would really look like. I mean, for you, it's every day, Stan, because you're
Yeah, no, I know. I mean,
now we start thinking.
I think it's fair to say when someone files a complaint or an answer, provides their contact information, they're generally expecting to hear from us. They shouldn't be offended to hear from us. Yeah.
I'm
But-
just imagining it playing out, let's say Melody's the one that does it, and now they're calling her during school. Obviously she can't.
So there's a piece to this fact finding conference that I just wanted to touch on. So at this part, in the event the complaint's resolved, the commission shall notify the parties that the complaint's been dismissed and shall record the result of the fact finding conference as a notice of dismissal. But if it's not resolved, then within 30 days, we then will prepare the findings of fact and a conclusion as to whether the commissioner finds probable cause that an unlawful practice has occurred. So when we invite them to the fact finding, if they can't come to an agreement, that's when we can take an action. And then we actually have more grounds to expand I can't think of the word, our duties, I guess.
When the Human Relations Commission conducts a fact finding, typically the first portion of it is asking the parties, you think you can work this out? You want to talk, and we help that. And then they do get in. If it doesn't resolve, that's when they're going to get more into the nitty gritty of determining what happened. That's what fact finding means here. It's like,
So if either,
determination of evidence. Let me hear your testimony. Let me see what documents you have, hearing both sides. And then if the matter's not resolved or settled, issuing findings. And then remember, those findings can be appealed to Bucks County Court of Common Pleas.
Yeah.
That's the complete process.
so we can either expand our procedures under subsection 5, or if we don't elect to expand our procedures, then we can tell them to proceed with a filing to the Pennsylvania Court of Common Pleas. And then there's a whole subsection, and if we do decide to expand our procedures, and then there's a vote that takes place on if we find it unlawful or not. So there's a whole thing about, in the event that we do elect to expand our procedures, we have the authority to do X, Y, and Z. And it's all in there from pages 11 to 14.
Yeah.
So that's, yeah. I mean, hopefully they could come to a resolution at the fact-finding conference and but even if one of the parties doesn't show up, even if they decline to show up, then we have the ability to expand our procedures.
If the employer didn't show up, you would still need to find that there are facts that support.
I do believe that it
discrimination.
has to go through a board vote that we do expand our procedures. In here, the board of supervisors has to say, yes, you can expand your procedures to do more because you didn't come to a resolution.
Yeah, can you say again the 30 days and 60 days? Is it 30 days to go from contact to complaint filed, or all the way to HRC hearing?
The ordinance doesn't give guidance as to the timing of what we're supposed to do pre-complaint.
Okay.
When the complaint's filed, we have to serve that complaint on the employer within 30 days.
Okay.
We then theoretically should be scheduling a hearing within 60 days because we have to have scheduled a hearing, right? We should have a hearing within 30 days after the answer or 60 days after the complaint if there is no answer. So
essentially, when a complaint is filed, you have 30 days to send it out, and we can go ahead and schedule something for
or we could wait to day 31 and then schedule a hearing within the next 29 days.
It says the respondent shall file a written verified answer to the complaint within 60 days. So they have 60 days.
Correct, but we have to have a hearing within 30 days after the answer or 60 days.
If they don't answer.
If there's no answer. So that gives us virtually no time. Let me reread that. That's almost a mistake.
Yeah. So
we have 30 days to send it out. Once we send it out.
they have 60 days to answer. Yeah.
No, but it says 3A on page 9, says the conference should be 30 days after an answer has been received. So that would be 90 days total. That's easy. Then it says, or 60 days after the filing of the complaint, if no answer is received. Well, we wouldn't know if no answer is received until 60 days. So that seems to be internally problematic.
Is that just a miss in the ordinance itself?
I think, but we wouldn't even know. I mean, it would.
Yeah.
The thing that Kelly and Sam used to let us know about, but about the fact finding session versus mediation, because I'm kind of hearing this different things. I'm hearing that they could decide to resolve it at the fact find.
Right.
So those two things are not mutually exclusive, right?
When I talk about mediation, I'm not talking about at a fact-finding conference.
We're talking about these.
maybe
out-
fact finding wasn't the right verbiage to use. Is that too formal or too
No,
procedural?
it's the language that the state has been using.
Essentially, we just invite
for
them to
50
talk
years.
about it with their documents, with any like supporting documents that they have. They're open to bring it to that conference with us, which is not on public, not a
No,
public forum.
that's not it is not public under the ordinance, but um, it's not informal either. They are supposed not, hey, bring what you want to look at. They have to they have to be prepared to put on their case. That's why resolving something at a fact finding is not the same as having a separate mediation or conciliation. You didn't just prepare for trial or prepare for a hearing. You didn't show up with witnesses. You're actually taking the time out of your day, both sides, if you both agree, to sit and talk settlement. There's a totally different vibe to that. So, and it's not required. I'm just thinking that it's not required by our ordinance, but I don't know a deliberative body now that isn't at least considering mediation as a part of the process. And honestly, probably over half the cases I'm involved in now resolve in a settlement conference or a mediation or some sort of pre-hearing setting. So we may never get a complaint and an answer, but so I think a lot of this is, just that.
Yeah.
But we don't even know because we didn't actually get a complaint. We sort of got a complaint, but we didn't get an answer. There's that complaint could get resolved if I'm representing an employer and I get served with a complaint. I might not ever file an answer. I might pick up the phone and resolve the matter. We may never hear about that. So a fact-finding hearing is pretty far in the process. We may never get there.
Cathy, do you have the
I'm trying to throw something together right now. I mean, I'm sure there will be more feedback, but I'm trying to.
Go back to the actual hearing itself. So is that basically like the judge, jury, we make a decision there? The question I'm asking, because if the one person is the chair and the other person is the person on duty, would we consider there's any sort of bias with the person on duty if they walk them through the entire process of filling out the application?
I don't think that this hearing that we're talking about is where a decision is rendered. It's simply to say, by us at least, it's simply to say, you guys either work it out or you don't. And if you decide not to, we have the ability to expand our procedure based on Board of Supervisors, like
Wait, that's confusing.
how,
Yeah, I think expanded procedures are different from rendering a decision at a fact finding. We can render a decision, we have to render a decision of fact finding under the limited procedures or expanded procedures.
in the moment of the fact, we bring it back to the whole committee or whatever?
I don't think so.
No, I think we're
I think we're just
deliberating.
there to, yeah.
I think we're
It's like an unbiased party. And now this says, in the event that the fact-finding conference has been declined or they cannot resolve, the commission shall either elect to proceed with extended procedures outlined in subsection 5 or consider the findings prepared by the commissioners who conducted.
All right, this ain't gonna all be on one page. We're getting into extended stuff.
right.
So then, in that case, if they don't come to a conclusion, those two of you guys who were there have the ability to come before the board and discuss.
That's right. So
And come to a decision. That's what it is. If they can't resolve in front of the two elected out of this group, then those two have the ability to come back to the full group and talk about it.
But do we have any?
The full commission or the Board of Supervisors?
Says the commission. The commission shall accept or reject the findings by public vote and shall then provide the parties with the findings of fact and conclusion. The outcome of the vote and whether the person has been aggrieved has a right to pursue the matter in court by filing a lawsuit.
So the folks that hear the those that attend and participate in the fact finding, if it's not resolved, come back to us, tell us about it.
Mhm.
At a public meeting, we vote publicly to determine whether we want to, whether we want to accept those findings. And in any, or whether we want to have an expanded situation where there's the possibility for more investigation, more hearings, more information. That's what the expanded stuff is about. So for instance, that's the kind of thing we might want to do if there's a class of people who might be subject to the same issue. And it speaks to that in here as well. And then in any event, if we find that there's no cause, or if we find that there is probable cause and make a finding, we have to notify the parties that they can go to court. So that's the next recourse. The final recourse here, if it goes all the way through, is you get to go to court.
So, for example, at a fact-finding meeting, we found that the woman who came to us last month, we found out that every other person who got severance pay was pregnant, got twice as much as she got. And that was what we got in the fact-finding. Can we make a decision based on that time?
At that hearing, at that fact finding? No, no.
It goes to-
You,
We make a recommendation that goes to.
not at that fact finding. You,
not a-
you, but you're not, it's not even accepted by the commission until the hearing officers, those of us who are the hearing, come back and present their findings to us, and we vote.
If they prove that, then I guess it's up to the person who committed the discrimination to decide whether that they want to let them
I
have
heard
it.
the board, but does the board get involved?
No, commission, if we said board, this is the commission. Yeah. There's nothing in here about board.
The only time I brought up the Board of Supervisors is that if we elect for expanded procedures, we have to get their approval, which means
Okay. Received 60
an
days.
appropriation of funding for such procedures. That would have to be a vote
Now,
too, between everybody here if you wanted to appeal to the
Well-
Board of Supervisors to expand procedures.
Because I don't know that a decision gets.
I just crossed that out. I think you're done.
A lot, yeah.
Parties sharing whatever they want to share, the two or more commission members that are there are reporting everything, taking it all in, gathering all the information. Afterwards, then it ends. And then afterwards, the two or more, whoever's there can say, this is what we think should.
Yeah, they deliberate and they present.
Here, so that means not until the next schedule. Whenever the next meeting.
Unless I guess we needed an emergency meeting, which I don't imagine we're going to.
The only duration, the only, limit of time is to have the hearing.
Right. You would want an emergency meeting if you had some sort of an emergency problem, but not to comply with our ordinance.
It's, you know, I don't.
Yeah. And I wanted to comment on the question about whether there's a bias in helping people fill out a complaint. And I think there's a potential bias, but I think if that arises, it's because we've probably gone over the line and to be an advocate. But what I wanted to point out is we should offer the same exact assistance to an employer
Mhm.
that needs help responding. So
Yeah.
it's really, we should not view ourselves as in the service of claimants, as opposed to respondents. And for, just like an aggrieved person who's been discriminated against is entitled to our, to our award, an employer who has not violated our ordinance is entitled to, our award.
We're advocates for the process, not the person who filed the complaint.
I think so. Oh,
So,
there's no
in the
way we're
weeds.
ever going
Yeah.
to until you actually have the facts. Because that's when these rules make sense, when you apply what's occurring before you. You can never
Yeah.
catch everything.
Thank you.
Yeah.
can I do a quick Good to his, did you have a question, Myron?
That where Tara might share other issues again that you've been thinking about private forums and other things like that we can anticipate and get into our discussion.
And I think, you know, one of the things was telling too, like, am I allowed to do that?
Mm-hmm.
Because it became confidential.
Yeah.
Legal matter technically, but, I mean, these are sensitive things, being shared with someone's name on it.
Well, I think it should say confidential. Privilege is a legal term. Confidential is a term a lot of us use, so.
All get burners.
We also do that name for the emails put out.
You should,
I could do that before I send it to everyone if,
at some point, we need to know who's involved in order to recuse ourselves. Right.
Like, these are our neighbors, so we can know them. And
Yeah, I mean, if we're going to adjudicate something, you need to know whether you're recused, so you have to know. But yeah, I agree. In this situation, if we have no jurisdiction, we don't need to know the name of the person or the employer. We don't need that. Doesn't affect our analysis.
that's fine.
So I just want to go over, I mean, I quickly showed it to Stan, and I'm basically just doing the spreadsheet up to fact-finding conference. Right, process, because
That way we don't need 7
That's a
spreadsheets.
lot, yeah.
yeah, because otherwise we're gonna need 7 more. So the same contact me, the liaison, legal consult needed, city attorney evaluates jurisdiction, and then I did a yellow, if yes, jurisdiction. Send to entire commission. And then below that, HRC duty person, do we want to, tell me who you want to call that anyway, gives assistance as needed. And then it goes to issue addressed without complaint or complaint received. If we're going down from complaint received, it says within 30 days, response paperwork sent to both parties. And then arrow over to receive paperwork. If we receive it, then it's down within 30 days, a fact-finding conference. Or up, paperwork not received, then within 60 days, fact-finding conference. So sent, I mean, it needs to be served on the. Yeah, I mean, response sent, that's fine.
There's no template for that either. So if that wants to be an agenda item for
Yeah.
the future, like
Yeah,
if
I
you're
mean, I think
reaching
that
out.
was when we were talking about cover letters that
Yeah,
we brought that up.
Yeah.
That probably does need to be on the agenda.
what the cover letter should say. Right?
Yeah, I mean, that's kind of, we had talked about that before. Okay. Yeah, I'll send this out to everybody again, and,
you.
we can certainly take a look at it at next time too. But I think just taking it to the fact finding is probably enough for now. And then we get that far, we have to see what happens.
yeah.
Um,
That discussion was super in the weeds, but I think more high level, it's important to realize that we have the ability to do this. We have the I hate using the word jurisdiction, but for lack of a better term, like the board has granted us the opportunity to follow through on this stuff for the betterment of our community if we so choose. So we have that recourse, not saying we might not ever use it, but it's nice to know that it's in there in the words, in the message, that we do have the choice to do it if we so choose. I think it's important to remember.
Heard stuff, but I don't. And would it be helpful to say, here are the parameters from the legislation that we all should be aware of? Such as the timeframes, and it has to be one person. Would that be in here? Okay.
Kind of like an ordinance cheat sheet.
I think we all have the ordinance. First of all, it is not that hard to understand, at least the procedure parts of it. But I think when we get a complaint and an answer, that's the time to actually
Because if I-
circulate the deadline.
If I were a duty person, I'd like to have
Yeah.
a piece of paper around that says, "Oh, wait a minute, it's 109, it's been the 181st day or whatever it is.
Mhm.
And that's, just for context, that whole subsection, the procedure for complaints and expanded procedures begins on it's in the middle of page 8. So it's towards the bottom. The top half of the ordinance kind of gives context onto who we are, why we do it, and important definitions. And then the latter half of the document is saying this, in the case of this is what would happen. So I would refer to around page 8 to 11.
Send that out to us, and maybe I've already.
It's on the website under our page, lmt.org, boards and commissions, Human Relations Commission.
Well, and I put the relevant ones into the flow chart. Yeah, I mean, the other thing I wanted to mention, slightly digressing, is I sent the stuff to Katie to put on the website. I don't know. For Historical Commission, we were given the power to kind of deal with our own Slate Hill pages, which is much easier because the way I asked her to do it is not how she did it, and nothing against Katie. It's sort of just buried in there, and I don't like it. I just wanted to sort of name that. I had asked her to put a button and go to a new page.
Is it linked here in a verbiage? The way that the website's set up, I don't have access to the website. Katie does all of the posting, but the way that it's formatted, it can't be like in a certain box. So she put a sentence saying, if you want to file an inquiry form, click here, and it's hyperlinked. Or if you want to file the complaint,
Yeah.
click here. It's like the first sentence under all of our names. It's like,
I thought it should be another page and kind of called out a little bit more. I think it's really lost in there, but maybe that's just me. And like I said, I love Katie. It's not to,
You're saying that, but can we just provide some feedback to Katie? Is it possible to make it bold?
yeah, see, it's,
There it is right now.
and that big empty space to the right, there are just formatting issues where we can't get anything on that side.
yeah, you have to use like macros and stuff. I mean, it's fine and people should look at it and see if they're okay with the language I gave her. I just sort of kind of was throwing something together so we could get it up. Oh, you got to use the. Okay. Yeah, that's my only kind of complaint about it.
But we can ask her if there's a way to make that complaint form in a bigger box there, or something that draws more attention to it.
Yeah, we were lucky with this first inquiry that the individual's lawyer knew that we had a Human Relations Commission and saw it, because not everybody might have that privilege and have that information to know, like, oh, they have one, like, I've done your research for you. People might be on their own in this situation, so it should be.
Well, I also think once we feel comfortable, and I know we wanted to build a foundation, like it needs to go out on the socials and stuff saying that this is there too, to kind of try to get it out there. So maybe it's at least in the back of somebody's brain that they saw it.
I would suggest maybe sending any revisions or suggestions you have straight to Katie. Again, I don't have access to the website, so I don't want to be like a middleman and have it get lost. But yeah, if you.
Okay, other comments or questions about workflow? That, of course, addition. Okay, come up with something. So that was actually, point 4 is actually non-existent because we don't need response, workflow, and timelines for inquiry. We just sort of said it's one line, we would like to get back to some to business. And so I think what we've just done is point 5. So then the next thing is public comment. And to my knowledge, there's no public here. As usual, most attractive option on your weeknight evening agenda. So, any other open business before we adjourn? It feels like anticlimactic, but that was a lot of.
I think it was growing pains. I think it was a good discussion. Like, it's good to understand, have the conversation and figure it all out together, unravel it together.
Extremely eye-opening to have.
Yeah.
And it really felt, I felt a degree of optimism.
Yeah.
Really, like I was, Kelly, have we heard from the attorney? Kelly, have we
Mhm.
heard? Like,
Yeah.
I'm.
And I appreciate our liaison Supervisor Lewis, who was able to also be involved in that.
Yes, he definitely, we were all sort of nagging.
Yeah.
It's worth noting that it appears that we were the venue or the commission of last resort for this person. And I think that's likely to be the case. I think the federal and state laws provide a bit more of a remedy and a bit more consistency than what we could provide. But that's why it's discouraging, by the way, to hear that the Commonwealth Court may believe, hold on, the case doesn't actually say that yet, that we don't have what is explicitly in our ordinance. It explicitly indicates that that one of the purposes of our ordinance is to expand coverages to include things that aren't covered under the. Otherwise, why would we really need it? Right. I agree. So yeah, I'm going to do a little more research on that case and the cases it relies on. So. Move to adjourn.
Was that Byron who seconded that?